Okay, welcome back, everybody. This is the third part of the Vocational Science Freedom all-day online law class for redemption of your estate, and we left off with talking about process service affidavits. And this is all part of Drew's story as to what he did, and we had covered his court of record procedure where he defaulted the courts and then he sent it off to binding arbitration. And what you do, this is an aspect of, so you wait for them to enter the contract. Well, if there's a current case open against your estate by the corporate state, which is what was in Drew's situation, basically they have 30 days to discharge the charges against your estate and dismiss the case. If they fail to do this, then they agree to be the trustee of your estate, and they agree that they have to put up what is now a $300 million bond. I think when we did Drew's KW, I think I only had it at 150 million. A dollar is described and defined in the KW as a 1 ounce round of silver, an actual silver dollar, as per the Banking Act, and not worthless Federal Reserve notes. So we're keeping everything at law here. That's the bond for the potential fiduciary malfeasance that they may do against your estate, which of course they always are doing. And if they fail to put up the bond, then they agree to be sued for the same amount of the bond in your court of record and or to be subject to binding arbitration proceedings for that same amount. Again, the whole entire status doc process is about putting up a wall and claiming your status and putting you in the proper position before anything happens. Now, not to say you can't do it after something's happened, because clearly that's what you did, but it's always better to have all this stuff, all your ducks in a row before you go into battle, kind of thing. The status docs get served on whoever. In this case, it was the judge and the clerk of the court and the other gentleman. Oh, again, I think was a district attorney, but it might have been a sheriff. And then you wait until they basically enter into the contract. Then what Drew did was he filed the suits at law to challenge the jurisdiction of the inferior court, and then he defaulted the defendants, proving that they had no jurisdiction. We wrote up a default judgment against the inferior court and the judges that attempted to administer the estate. And I'll pull up the judgment that we did that got filed in the court of record, House of Nelson, County of Alamosa, Republic of Colorado. Special term at Alamosa County Courthouse, blah, 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 case number, and yada, yada, court of record. So default judgment, quorum ipso rege, and this is 8 pages, so it's not tremendously long. I won't go through the whole thing, but you do your introduction, your jurisdiction, your facts, your conclusions at law, your judgment, and the reason that the Federal Rules of Civil Procedure is in here, even though this is a state court, is that Drew picked the Federal Rules of Civil Procedure as his rules for his court. So he decreed that those rules were going to be the rules of his court. And that's fine. If you decree it to be the law of the case, that's okay. But you're not just doing it to say, oh, because, I'm in a state court, I'm using federal rules, which seems kind of goofy, but the Federal Rules of Civil Procedure are very easy to read. They're pretty short. They're concise. They're simple. And what we said in the law of the case, which I'll pull up for Drew's case in a minute here, we said that the Federal Rules of Civil Procedure are the rules of this court as long as they're not repugnant to the common law. So you give yourself a kind of a catch-all. You give yourself a protection by stating it that specific way. So, introduction. All of the served counter defendants have either demurred or defaulted. No facts are in controversy. All that remains is to refer the law arising thereon to the court. This case turns on a single question of law. Do the defendant actors have jurisdiction? The facts presented to the court show that none of the defendants were injured. There is no corpus delicti. Further, the subsequent courts involved were courts of inferior jurisdiction, even though they were otherwise courts of general jurisdiction. Further, defendants acknowledged that when the jurisdiction was challenged, they ignored the challenge and assumed the jurisdiction without proof, or the court itself attempted to prove its own jurisdiction. This court of record now proceeds to judgment on the demurs and judgment on the defaults. Jurisdiction of the court. The first duty of a court is to determine whether or not it has jurisdiction. The jurisdiction is established by the plaintiff when he claims an injury, selects the forum, serves the defendants, and the defendants make personal appearances. Jurisdiction is the authority by which court take cognizance of and decide cases. This authority comes from the sovereign people of Colorado, who do not yield their sovereignty to the agencies which serve them. And that particular little line can be found in all kinds of various different places. We found this exact line in Oregon Public Records Act. It's also in the California Government Code and in a few other places in various different states. It's just truth in of itself, even if it wasn't in some code. It is just truth as it's stated. In the counterclaim, plaintiff asserted without objection that he is one of the people of Colorado and that his selected forum is a court of record. The defendants were duly served. Defendants personally appeared before the court by attorneys and general demurs or defaulted. This court comes now to enter final judgment on the demurs, final judgment on the defaults, and to order defendant and magistrate to show cause, if any there be, why these judgments should be rescinded or modified. And here's the thing: when you do the show cause thing in it, you're still giving them a last chance to be like, look, if you want to argue any of this, if you want to say I did any of this wrong, you still got a chance to argue it. But they never did. So this court concludes that because the plaintiff's status as a people, his counterclaim, injury, trespass of the case, the defendants were properly served, the defendant personally appeared in this action or defaulted, this court has jurisdiction over the subject matter and in personam and may proceed to judgment. The record of this court reveals that the defendants were duly served. A summons was contained within the action in accordance with the common law procedure. The record is the court. The magistrate is not the court. No denial of the court of record was placed on the record, and the defendants entered no facts on the record to dispute any claim or fact presented by the counter plaintiff, and thusly have agreed to the remedy requested. The counter defendants made no request for a jury and made no request for a hearing. This court has authority to act based on the record, as the record is the court, and the judgments of the Superior Court of Record arise from the court. The acts of a court of record are known by its records. Judicial records are not only necessary, but indisputable to the administration of justice. The court judgments can be evidenced only by its records. Anyway, I read this before, but so you get the point. So, facts. The respondent against whom the judgment or affirmative release is sought have failed to plead or otherwise defend as provided by these rules, and that fact is made to appear by record. Now, therefore, this court of record issues this default judgment quorum ipso rege to dispose of the matter as law and justice require to wit. The following uncontested facts are taken from the plaintiff's verified counterclaim. No opposing facts were submitted to the court by any of the defendants. The facts of this case, by reason of defendants' demurs and defaults, are fully admitted by the defendants. The record shows the suit at law filed was appropriate for an action at law. The filing was into a court of record that proceeds according to the common law. The body of this countersuit and the decreed law of the case placed the filing into common law. The defendants were served. Lawful summons was contained within the service. Yada yada. Declaratory judgment is appropriate. The plaintiffs have made, that should actually say final judgment, not declaratory judgment, but whatever. The plaintiff has made claim that the inferior court acted without jurisdiction, capacity, or authority, and has made claim that his substantive rights have been violated. Therefore, plaintiff is entitled to obtain a declaration. His rights pursuant, it should say declaration of his rights. That's, yeah, I probably would have worded that differently. Pursuant to, this was the aspect of the Colorado Rules of Civil Procedure, because I think Drew actually did both. But be careful of that, because that, I don't know if Drew put this as a misprint in it. It should have been the Federal Rules of Civil Procedure, but anyway. Declaratory judgment is appropriate in this case because in order from the Superior Court of Record, a court of last resort will resolve uncertainties with respect to parental rights and rights within the inferior court that have been allegedly denied. Argument and finding in regards to the capacity of the inferior equity court, the records reveal and the court finds that the charging instrument submitted to the inferior court in both those cases was not a valid charging instrument to give capacity for the court to proceed based on the criminal actions of the officers who wrote the charge, which was what was stated in Drew's other counterclaims. So there were other counterclaims that against other people from the standpoint of what they did. When an officer violates law, he is stripped of authority ab initio and therefore could not write a valid charging instrument to give the inferior court capacity. And that was from the aspect that when Drew was arrested, they never took him before the nearest and most accessible magistrate. So they decided to punish him before they had jurisdiction. In regards to the jurisdiction of the inferior court acted without capacity, which renders all of its actions and orders a nullity. However, for the record, it behooves the Superior Court of Record to take actions to nullify the actions of the inferior court on the record so that no ambiguity remains on the public record regarding this matter. The record of the Superior Court and the court finds that the counter plaintiff challenged the jurisdiction of the inferior court. The inferior court judge Waltz abused his discretion in not requiring proof of jurisdiction on the record and arguing jurisdiction on his own accord, prosecuting from the bench, thusly depriving the counterplaintiff of due process by arguing for the opposing party, negating the requirement placed upon him by law of staying neutral. Oh, and by the way, this is a different finding of fact and order than the case that I just read. Drew had multiple cases, and this was just one of them that I picked out. I'm sorry I didn't pick out the exact same one that matched the past case, but that's probably why this one said Colorado rules of civil procedure instead of the federal rules of civil procedure. So the record further reveals that no answer was given at any time to the jurisdictional challenge based on the deprivation of due process, and in lieu of requiring proof of jurisdiction, Walt simply made excuses as to why he took the role of prosecution, because that's not what judges are supposed to do. The record reveals that no answer to the jurisdictional challenge was ever placed on the record of the inferior court, and the inferior court proceeded with no proof of jurisdiction on its record. And some cases to prove that. Final orders and judgment. Superior Court of Record finds in favor of the plaintiff. No return was entered from any defendants. It is ordered and adjudged that the inferior court has acted arbitrarily and without care, has abused its delegated authority, and has acted not in accordance with law, but under color of law, and in excess of its vested constitutional jurisdiction. The inferior court is now ordered by the superior court to be divested of all authority and jurisdiction regarding the matter of Brent Andrew Nelson. It is ordered and adjudged that the state of Colorado counter-defendant owes damages in the amount of that for unlawfully administering the estate counter-plaintiff and for the humiliation and intimidation caused by said counter-defendant. Counter-defendant's disregard for counter-plaintiff's substantive rights. And here's the rest of the things that it was. That's $120,000, $650,000, $5,000, whoever this guy was. Wazel was for about $500,000. And this one was for about $250,000. And this is like all of the rest of them, kind of put together. All the rest of these people that trespassed and didn't answer. So anyway, so that's all that. And so he signs it, and this is important. You sign it alternatus privatus, which means private attorney. Drew signed for the court as a private attorney, not in his capacity as plaintiff, but in his capacity as a private attorney for the court, because something has to speak for the court, and you can do it by private attorney. And this is exactly, by the way, how Bill Thornton does it. And so then you have your sign, your seal, and you're done. And then it gets filed into the court, as obviously it did on August 2nd, 2018. Okay, so that's the order in default. So after he defaulted him, the inferior court kept moving forward. And so he came to me and Drew said, okay, so what do we do now? I'm like, well, let's file for binding arbitration. So all those documents, all the filings, all of the original actions that Drew had done in courts of record were all then sent to the arbitration company. They were all sent to Sitcom. So then they picked an arbitrator who then took a look at all the information and took a look at the status docs, the KW, and found that the defendants had entered into contract and that they were bound to perform the contract. And so the stuff that was included was handout 11. Or maybe I did have his... Oh, no, I missed it. Sorry. Yeah, I was going to put that in there, and then I think I came to the conclusion that I couldn't find it. I'll have to ask Drew for it, because I know he has his original application to Sitcom to do the arbitration process. Every arbitration company is going to have its own little bit of paperwork that you got to fill out to do to have them do binding arbitration. All the status docs that were process served on the enemy, the evidence of the service, meaning the process service affidavit, as I said before, evidence of the time and place where the other party entered into the KW contract, so the administration of the estate, where it occurs, so on and so forth. And I don't need a number 5 there. That was all given to the arbitration company. And the defendants failed to argue the arbitration as well. They basically felt like, well, we don't need to show up for this. They don't have jurisdiction. Well, you did have jurisdiction, and you are bound by contract, and the arbitrator found that to be so in all 3 of Drew's arbitration awards that were against different people for different reasons in different cases, basically. And I'll show you where that is. And basically what happens in arbitration is that, and this is what we had heard from various different arbitration companies, is that they'll tell you that 90% of the time the other side just doesn't even show up to the hearing. This then ends up in an award given to you in your favor. However, you do always need to be ready to argue the KW contract and, the where, when they entered into it and in what way. So just make sure that you, in case they do show up, say, yeah, so and so entered into the KW contract on this date because I had challenged jurisdiction of the court and defaulted them that they didn't have any, and they kept moving forward in the administration of my estate. And that's it. I mean, that's all you have to say to have them enter into the contract. Then we can look at what Drew's awards were as far as the arbitration awards. So number 12 in the folder is I believe this is the first arbitration award? Yeah, because Keisha Jones was the first arbitrator. So, and all these extra numbers up here, because this is where Drew filed this into the county recorder's office. He got this binding arbitration award, and then he took it and he filed it into the county recorder's office, which then ended up being a lien against the judge's house. And he did this with each one of the awards too. So this is the one that's got the print off for the county recorder number. Okay, so what did the arbitrator do? This is who it was: claimants, respondents, and final arbitration award. Breach or violation of required contract terms. The parties have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration, and shall specify the court then at any time within 1 year after the award is made, any party to the arbitration may apply to the court so specified for an order confirming the award. And thereupon the court must grant such an order unless the award is vacated, modified, or corrected as prescribed in sections 10 and 11 of this title. And what they're talking about is Title 9, because it's under... Now, I don't necessarily know exactly why the arbitrator did this. Technically, it really shouldn't have been under Title 9. It should have been under Colorado's... the arbitration statutes of the... Because here's the thing. There's the FAA, which is the Federal Arbitration Act, which is Title 9. And then there's the UAA, which is the Uniform Arbitration Act, which is what all the states have adopted through the Commission on Uniform Laws, which is a filthy group of attorneys that meets in Chicago every year that basically is by their own deciding what is and what is not going to be state law. So technically, I don't know why, and this is kind of a problem, sort of, that we've run into, that it really should have been filed into the state court for confirmation. But considering that they basically blocked Drew from filing anything in state court because he went at him so hard and defaulted all these judges and whatnot, that we've been filing for confirmation in U.S. District Court. This is based on Title 9. Okay, so if no court is specified in the agreement of the parties, then such application may be made to the United States Court in and for the district within which such award was made. In this case, it was Georgia. The arbitration happened in Georgia. And that's fine. The arbitration can happen wherever the arbitrator or the arbitration company's at. It doesn't have to be in the same state. So notice of the application shall be served upon the adverse party, and thereupon the court shall have jurisdiction of such party as though they had appeared generally in the proceeding. Now, all that language comes directly out of Title 9. If the adverse party is a resident of the district within which the award was made, such service shall be made upon the adverse party or their attorney as prescribed by law for service of notice of motion in an action in the same court. If the adverse party shall be a non-resident, then the notice of the application shall be served by the marshal of any district within which the adverse party may be found in like manner as process of the court. And again, this is all from Title 9, which is what it's here, the June such and such whatever statute. Arbitrator's name, Keisha Jones. And this is, again, this little thing right here that's the county recorder's stuff, not anything to do with the original award. Okay, so hearing location, Athens, Georgia. This arbitrator has considered the claimant's request for dispute resolution on complaint and finds as follows. Jurisdictional allegations. This arbitrator has subject matter jurisdiction as acknowledged by 9 U.S.C. blah, 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 and the established common law, not limited to the following specifics. That Brent Nelson is a citizen of the state of Colorado, lowercase s state, and the respondents, yada, 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 entered into a contractual agreement on or around May 24th, 2019. It is uniformly settled, and this is the KW that they're speaking of here. It is uniformly settled that a court's right to vacate or modify an arbitration award is extremely limited. That said, many state arbitration statutes, as well as the Federal Arbitration Act and the Uniform Arbitration Act, which is what I was just talking about, allow correction or modification of an evident miscalculation in the arbitrator's award. See Title IX, whatever. Many state courts have held that an award can be corrected only for miscalculations that appear on the face of the award and for mathematical errors that are patently clear. This arbitrator, Keisha Jones, has been appointed in the above referenced matter on behalf of Sitcom Arbitration Association to settle and resolve any and all disputes arising thereunder by arbitration under the authority of the Federal Arbitration Act. An arbitration hearing was held on November 27th, 2019, at which time the arbitrator reviewed all contractual agreements and documentary evidence submitted by the parties in this matter. That would have been the KW and everything else, the court cases and everything that Drew had defaulted them on. This arbitrator fully considered and granted the claimant's request for summary disposition and further considered all the evidence in reference to the contract, item number, yada yada, its terms, promises, and obligations, as well as the facts in support and presented during the arbitration of this controversy. On about May 24th, 2019, claimant and respondents entered into a written, irrevocable, binding contractual agreement, which included an arbitration clause. Both parties entered into a legally binding contractual relationship, and this arbitrator found that no fraud in the inducement to contract or fraud in the factium was present. So what the arbitrator just said is that basically the way that we force them to enter into the KW contract is lawful. There's no fraud in it because they don't have to enter it if they don't want to. Thus, respondents are bound to the terms and obligations agreed upon and imposed on them. That's everything in the KW. To date, the respondents have failed to respond to the claimant, and this arbitrator has found that the respondents were not willing to participate in the hearing. Therefore, after careful consideration of the evidence presented, the arbitrator finds as follows. The claimant, as well as respondents, are consenting adults, having attained the age of majority. Obviously, that should have said having come of full age, but whatever. Not a minor, not an infant, not a delinquent, and or a decedent. Again, the arbitrator realized you're not dead, you're not an infant, you are, again, it should say having come of full age, but it's fine. These other things take care of it. All parties are fully capable of entering into and negotiating contracts. And I do not find any of the parties to be suffering from a mental disease and or defect that would have prevented and or interfered with their knowing and intentional entering into the binding contractual agreement. And the arbitration hearing was held on November 27th, 2019, at which time this arbitrator reviewed all contractual agreements and documentary evidence submitted by the parties in this matter. The arbitrator fully considered and granted the claimant's request of September 3 for summary disposition and further considered all the evidence in reference to the contractual agreement. Again, talking about the KW. A prior relationship did exist between the parties, and respondents had an obligation to respond to the reasonable request of claimant. Yeah, I'm not going to read all the rest of this, but anyway, I can skip down to the bottom. These are all the rest of the things that basically followed. This arbitrator finds that claimant had demanded liquidation of the estate trust and that the respondents have failed to act. Yes, exactly. The claimant has also demanded a full review and audit, comprehensive in nature, of all revenue for the estate trust over the course of the past 10 years. That's actually not just past 10 years, but it's forever. But anyway, any tax credits and or deductions associated with any estate trust, a copy of the insurance policies held, and a copy of any bonds held by the debtor. Well, the KW's got a more exhaustive list than that, but it's okay. The claimant, also acting as the creditor in this matter, has requested such information to preserve their standing and position. It is ordered that the following case numbers, which were all the case numbers that they tried to come against Drew at, and any other cases against claimant past and arising, its judgments, orders, pleadings, papers, and sentences are void ab initio. The arbitrator found that the cases that Drew had defaulted them on, said, no, you don't have jurisdiction, upheld the fact that they didn't have jurisdiction. Okay, and now it's in a binding arbitration agreement, or award, sorry. Retaliation or any sort of backlash will result in the claimant recovering retaliation damages equivalent to 5 times the amount of actual damages if any further injury is inflicted. Now, this was something that I didn't have in the KW. The arbitrator just did this. I have it worded differently in the KW. What it does is that it says, look, if, well, actually, you know what? Come to think of it, Drew's KW, I might have had it. You know what? In Drew's version, I think I did have it worded differently because that was before I did the full redo of the KW, where I put it into. Now there's all these sections in the KW where each time that you continue to administer after a certain time, or if you take certain actions, like a retaliatory action, the penalties get more severe. So I think I had something akin to that, but it wasn't written in the same way. So that's what the arbitrator put in there, found that. The respondents failed to provide proof that they have not received and or notified of the existence of the contractual agreement and of their right to waiver because they got process served. Respondents failed to respond to the contractual agreement mailed with proof of service by the claimant on September blah blah, which constitutes an act of tacit acquiescence, right? So they agreed to the contract because they took an action inside the contract that bound them to it. So the respondents have failed to fully perform to the terms of the agreement, and the claimant is entitled to immediate and unconditional remedy as prescribed within the terms of the contractual agreement. And 9, furthermore, this arbitrator finds that the amount stipulated to be paid to the claimant is $500,000 from respondent Carrie Ann Yoder, who was a judge, et al. This amount was derived to recover some of the loss experienced and for trespass of claimant's property and rights as stipulated according to the terms of the contractual agreement as agreed to by the parties. The amount stipulated to be paid to the claimant is $500,000 from Talbot, well, I think it was another judge, and $500,000 from Ashley M. Bergmeister, who I think was a third judge, and then $500,000 from Corwin Jackson. Total combined award amount is $2 million, as stipulated according to the terms of contractual agreement, as stipulated by the parties. The respondents have 30 days from receipt of this award to comply with the decision of this arbitrator. In the event that the respondents fail to comply with the decision of this arbitrator may revisit this matter upon request of the claimant and according to the terms and conditions of the contractual agreement, which was the KW, to modify this award in an amount equivalent to 2 times the determination of this arbitrator for each respondent, which gets really big. The contract stated that any final and binding arbitration award may be confirmed in any United States District Court pursuant to Title IX, yada, yada, yada. I don't think that's exactly the way I worded it in the KW, but that's what the arbitrator put in here. But the fact is they never argued it, so whatever. The Supreme Court has explained there is nothing malleable about must grant, which unequivocally tells courts to grant confirmation in all cases, except when one of the prescribed exceptions applies. And of course, they have to bring that up within 90 days. And if they don't bring it up within 90 days, the arbitration award is considered cured. And then there's nothing they can do about it. Which is exactly what all of them did. A judicial review of an arbitrator's award is extremely limited, and the court must accept the arbitrator's credibility determinations even where there is conflicting evidence and room for choice exists. An arbitrator's award should not be vacated for errors of law, in fact, committed by the arbitrator, and the court should not attempt to mold the award to conform to their sense of justice. And these are all cases that she has listed down here, that little footnotes. Claimant may seek confirmation of this arbitration award in the United States District Court, as was stated. Confirmation of an award is generally a summary proceeding that merely makes what is already a final arbitration award a judgment of the court. And again, that's right out of a court case here. This is important. Once you get a binding arbitration award, it's a summary proceeding to confirm it. None of these judges and none of these filthy bastards have any capacity to deny it, particularly after it's gone past 90 days and no one's argued it once it's been cured. Now, what the U.S. District Court has been bitching about is they're saying, well, we don't have jurisdiction because all of you are in the same state and there's no diversity of citizenship. Which, from a certain point, I get their point, but at the same time, I don't, because it's not an action. You're not coming upon the U.S. District Court to determine anything. It's supposed to simply just be a summary proceeding that gets done and is finished, which is exactly what, where it's stated in Title IX that you can bring confirmation of the award in the place where the award was granted, which would be Georgia in this particular one. So when Drew filed his confirmation in the U.S. District Court in Georgia, they should have simply just rubber stamped it, been like, yep, that's it, I'm done. But they didn't, and on top of it, the judges hired attorneys to try to file motions to dismiss the confirmation and yada yada, this, that, next thing, trying to argue the arbitration process and trying to make arguments about the arbitration company, which are completely irrelevant because it's the arbitrator that did the award, not the arbitration company. After it was cured, after 90 days, there was nothing else to be done except confirmation. That was the end of it. I think I'm going to get a hold of my particular friend who is very good at dealing with their process. He's also been in federal court, like, I don't know how many times. And ask him and be like, look, considering where this is at, what do you think, we should do here? And have him kind of look over Title IX and check out what this whole process is and see if we can't come up with a solid thing to do, or maybe even write an appeal to perhaps the appellate court in Georgia, or maybe even the Supreme Court. I'll see what he says about it. In the meantime, the thing is still open in Georgia, and Drew also filed in Colorado for confirmation as well. That's still open and pending also, but my guess is that the Colorado ones will be like, they probably won't. Again, they'll probably come up with something like, well, it's diversity of citizenship and blah, blah, blah. It's that you guys should be filing this in Colorado State Court. Well, problem with that is that they're not allowing him to file in Colorado State Court. They banned him from all the courts. So how do you confirm an award that you can't get into their court system with? Well, that's something that we're going to get into later today, because I fully believe that there's no problem whatsoever to appoint a special master, convene a court of record, and have a petite jury render a general verdict. Yeah, the arbitration was performed in Georgia, yes. Or that's where Keisha Jones was in Georgia. His other two arbitrations happened in California. The idea that we can be able to confirm, and particularly that a jury under general verdict could confirm an arbitration award, there's absolutely no part of that I can possibly see to be incorrect as per the common law. It's all correct. All of it we could do ourselves. The more extreme version of it, I was thinking, was that we could convene a 25-member grand jury and then investigate into the state court's refusal to let this man file anything as far as his confirmation is concerned. But that's the kind of thing that Drew will have to decide one way or the other. And maybe my guy will come up with something that'll just blow right through their little cock blocking procedures that they're trying to do. Drew's written up a private bill to the Colorado legislature to pay off these amounts, even though technically in a weird way, Colorado legislature, it's really none of their business because these people all owe Drew in their private capacity. But what was weird was in U.S. District Court in Georgia, the Colorado Attorney General decided to show up into the case and filed a motion to dismiss and blah, blah, blah. They have sovereign immunity. Wah, 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 wah. Well, no, you don't. And that's something else that this particular friend of mine that I was telling you about has court cases proving. My friend was helping an old woman in federal court because there was something like a $125 million estate that her husband had died, and all of these attorneys were like basically keeping the money from her. And so he filed on her behalf against all these attorneys and all these judges, and it was a lot of defendants. And they were all whining and saying, oh, we're immune, we're immune, we're immune. And the federal judge said, all right, had them all in court one day and said, and went through the whole entire defendant list. And so is so here. Yes, you are. Stand up. Is so and so here? Yes, I am. Stand up. Is so and so? Yes, I am. Stand up. She ran through the whole defendant list, told every single one of them to stand up. Then she said, I'm going to give all of you 3 court cases. I want briefs on these particular 3 court cases in 30 days. I'm not going to hear anything from either side until this is done. And then told them to fuck off and go get it done. Well, what was extremely interesting was that these 3 cases all had to deal with the fact that the state is not immune because, and this is the beautiful reason, is that the purse strings of these courts are separate from the state. They have their own Dun and Bradstreet numbers. They are their own private little filthy entities. And that was exactly what she was making them all go and brief out to force the issue and be like, I don't want to hear this ever again. You guys are not immune. And what happened with that was basically like after they went and read the cases, they knew they were screwed. And they basically gave everything back to the woman as best as they could, that they were hiding and trying to put into different places and whatever else. So anyway, my particular friend, he's going to come over on Monday. I'm going to ask him, be like, look, can you bring me those 3 cases you were telling me about before? Because I really want to take a look at them, and we should be able to use them then to run these idiots over. Because if one federal judge is aware of it, well, then the rest of them should be aware of it, or they're just corrupt. I don't know which, and I don't really care, because everything that we're doing is 100% correct. And I'll get into that too after I get done with this award. I'll show you the other 2 awards that Drew has gotten, and then we're going to go over Stark's award. Stark's award, there's a whole story behind this. What Stark did was not our process exactly. It had parts of our process in it. I've never talked to Stark. I've never met him. I don't know any of the other people that are in the private bill. But Stark took his thing and went to the federal Congress and put in a private bill of which they passed into law. And the arbitration awards in that private bill are in the trillions. And the bill itself is now considered national security. And you can't find a copy of it. But guess what? You guys get one because I have one. Because I pulled it before they did that. So anyway, all right, let's finish up this award and then I'll get into Drew's other 2 awards and then I'll get into Stark here. Does denial by a state court prohibit an arbitrator from filing in the blocking state? No, the arbitrator doesn't file anything. The arbitrator just grants the award, and then the one who the award is for, in this case Drew's the one that has to do the filing. There's sections in the UAA and the FAA that specifically block an arbitrator from filing for confirmation. Even if they wanted to do it for Drew, they can't. So it has to be something that Drew does. Now, I had talked to Drew about the possibility of saying, look, dude, you've already got this thing already locked up and completely done. Maybe it would behoove you to go ahead and find some really, highly intelligent but also nasty ass attorney firm and say to them, look, if you can get this thing confirmed, I'll give you 10% of the award or something like that, right? Right up to contract where the firm gets 10% of, all of these millions of dollars. I really can't see how a filthy attorney wouldn't jump on that, but Drew hasn't really pursued that. We're still just doing everything ourselves and to see how far we can get it, to see if we can just get it without the attorneys. So with status docs filed, could a petition of remonstrance be filed like the people did prior to the Reconstruction Acts? Well, yeah, that's basically what it is. I mean, that's a petition of remonstrance is basically a private bill. That is what it is. And the thing that you got to understand about what happened during the Reconstruction Acts and what really changed the federal court system is that prior to that, all the private bills were going through Congress because it was the only way to make the United States basically pay, is that you took a bill to them and said, look, you owe me, pay me. And you had to do it through Congress. Then what Congress did, and this of course is after the Reconstruction Act, so it's shady anyway, but what they did was they created what's now called the United States Court of Claims. And what they said in the creation of that court, which of course they have the right to create courts, I'm not saying they don't, because that's in the Constitution, but what they said is that basically the U.S. Court of Claims was the only place that you could bring a suit against the United States to make them pay you. And it was a way to stop all of these private bills that were just, it was just impossible for Congress to go through all of them because they were all kinds of things, from all kinds of war reparations and all kinds of crazy stuff from the Civil War. I don't want to get into all of it because it's lengthy. But so they created the U.S. Court of Claims. Now, what I was thinking, because I do know a few people that I guess have worked with Stark, or at least like know what he did and whatever. I was wondering, like, after they got the private bill passed, Stark's private bill passed, that why doesn't Stark just take it to the U.S. Court of Claims? I don't know if they've done that yet, but I'm keeping it open to possibility. So anyway, let's get back to finishing up because we're almost done with this award, and I'll show you the other two, and we'll get to Stark in a minute. Okay, so this award is final and binding between the claimant and the respondents in the above reference matter upon issuance and execution of this arbitrator's signature below, and full force and effect take place immediately upon issuance. Notice of the issuance of this award to be delivered to the defendants. Like I said, I think these are all judges. Might have been an attorney in here somewhere. So awarded. So be it so, this such and such day, and Keisha Jones, arbitrator, with her arbitration seal. And yeah, it was from Sitcom. And then this is where Drew had filed this onto the county recorder's office. So that's award number one. Award number two, final arbitration award, breach of violation of required terms. And again, I'm not going to read this whole bloody thing because it's pretty much tantamount to the same thing of what the other one said. But there's different defendants here. And I'm just going to scroll down to the bottom. So this arbitrator has read the agreement, and it is noted that the award is not to exceed $10 million, noting the initial default by the respondent, the consent to the obligations of the agreement, and the failure and or refusal to comply. This arbitrator does find that the default has not been cured, was deliberate, and hereby orders the respondent, Daniel A. Wazel, in his official capacity, and that should have said not in its official capacity, because this is what I think the arbitrators aren't paying attention to, is that we're not bringing this in their official capacity. But when he says it like this is what I think is allowing the Attorney General to jump in here and go, oh, we're immune, blah, 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 whatever. Anyway, to pay to the claimant $6 million to comply with the terms and conditions of agreement. Failure to comply may result in an award that is accompanied by sanctions. Okay. Therefore, decree the arbitrator, respondents, so on and so forth. And this one was done in California. Okay, so that's that one. Next one, same kind of thing, but again, and this was the same arbitrator, Brent Jones, but again, different set of respondents here. So this was the third time that Drew did this. Again, you scroll down and you get to, oh, I think this was a response. Wait, hold on. Was it the response to the second one that Eon had to do second because they didn't follow what they were doing? Is that what it is? Because I didn't see a monetary amount here. Contracts agreeing all elements of trust agreement as the estate and or trust are held in by the custodian. Sovereignty, but at a subsection minor account. Oh, that's an interesting piece of. I don't know if I've ever looked that up before. With respect to trust agreement, the estate and property and the claim held in control respondent is held. They comply with the agreement. Oh, durable power of attorney is also deemed valid and binding. Yeah, what we did was, there's a part of the KW, and this I did take directly from Stark, because when I saw it, I was like, ooh, that's just evil. What Stark did is he took power of attorney over Eric Holder, who, in case any of you don't remember, was the Attorney General under Obama. Congress found that was valid. Once he did that, he basically then had the capacity to sign Eric Holder's name onto documents, which he then dismissed his own federal case, and again, Congress agreed with him. I don't see the dollar amount here, so maybe this was something contractual, also valid agreement. So supplemental award and sanction order might have been part of that. So basically what he said is that because they haven't done what they were supposed to do and dismissed the cases, okay, the award ordered for each respondent was the $500,000. And additionally, this arbitrator orders the respondents are liable to the claimant for the following additional charges on the top of the $500,000 that respondents were already ordered to pay. that for the attorney's fees and legal fees, all taxes on the award, all taxes related to the award. The respondent's custodial agent, okay, all records are to be immediately expunged, erased, and any pending charges, duties, etc. are deemed dismissed with prejudice. And any and all parties who allege custody, charge possession, or have assumed control over claimant, claimant's estate, claimant's assets, claimant's trust, and or other indentures are ordered to release such immediately as claimant demands compliance. They gave him another 14 days to basically do that. Claimant may note that respondents by law must be bonded, and this award may be presented by placing a lien on the assets of the respondents and or garnishment of their wages by the filing of a UCC1 financial statement. Now, I don't know if Drew's done that or not. Okay, this was the other part. All right, respondents are collectively held in contempt of court for each such breach and sanctioned individually. 70,000 and collectively 200,000. Each separate sanction is to be paid to claimant by April 4th, 2020. Failure to comply with will constitute willful and deliberate acts while in office and misprision of felony. That was the acts with the updated award that Keisha Jones had originally done, and because they weren't complying with it, then he did this one as an update. So when Drew took this award and he went and he filed it down at the county recorder's office, this is what he got when he looked it up in the Secretary of State's office. Now this is official as you can get. Okay, so Daniel Austin Wathel in his capacity with the state of Colorado. Okay, with. This is on the Secretary of State's website. Okay, so when he put the arbitration award down, it said what it was, and it said claimant individual, Nelson, Brett, Andrew, address, property, description, all goods, chattels, lands, tenements, and real estate. Daniel A. Wathel in his capacity with the state of Colorado. I mean, if you read this lien literally, Drew just basically liened all of Colorado. Like the whole fucking thing. Now, if that isn't something interesting, and like I said, this is directly off the Secretary of State's website. It's not like, not like we're making this up. Well, actually, no. What Drew found out was he found a statute that said that a judgment filed onto the county recorder instantly becomes a lien upon the assets of basically the defendant or the respondent, whoever the defaulted party was. And he made a note of that and took it down to him when he filed the arbitration awards in the county recorder's office. And the county recorder was like, "Oh yeah, no, yeah, they're liens. They become liens." And Drew's like, "Okay, great, thanks." And then he got this, and but it's a little crazy from the standpoint that Daniel Wathel in his capacity with the state of Colorado. And this, of course, is the state of Colorado. This is the corporate state. So everything that the corporate state owns, Drew literally has a lien on. So in a funny way, Drew could literally foreclose on the entire state of Colorado, meaning the entire corporate state. He could do that for his arbitration award, just simply based on this statutory lien that's filed with the Secretary of State. For no other authorities would be necessary. That's it. Which I'm also going to bring up to my friend and be like, can we just go this route and just foreclose on the lien and just be done with it? I'm thinking he's going to say yes. We'll have a conversation about it on Monday. We'll see what we come up with. But I mean, the point is that they can't get out of this. It's beyond cured. I mean, it's cured to the point where there's a lien, and the Secretary of State agrees that there's a lien on the state of Colorado, and not to mention Wathel. And oh, by the way, this asshole, as soon as Drew, and I told him not to do this, but he did it anyway because Drew's a little bit overzealous, as you could probably guess. What he did was, as soon as he got the awards, he basically, I don't know if he process served them the awards, but anyway, he basically gave them notice that they'd been defaulted. And this prick, Wathel, what he did is this judge had 7 different houses in his name. Wonder how a judge gets 7 different houses. Yeah, anyway, particularly in Colorado. And they were all nice big houses too, by the way. We're talking like over $1 million. Drew was watching the land records